Good morning and welcome to those of you joining us on Zoom. If you'll just give us a moment to let folks load into the Zoom room, we will get started momentarily. Good morning and welcome. We've had a busy couple of months at WITA with in-person, hybrid, and Zoom events, and we're glad to welcome you back to the WITA Zoom webinar platform. Before we jump into today's topic, we have a few big things coming up, starting Friday with the WITA Academy, which is hosting its second Pathways program for students at the University of Delaware to learn more about careers in international trade and business. We also hope to announce a three-part program for students at Howard University in the weeks to come. We're also pleased to announce that we will be hosting Dr. Ngozi Okonjo-Iweala, the Director General of the WTO, in person at the Reagan Building in Washington, D.C. on April 12th. That event will also be live streamed for those of you who cannot join us in person. Information on all these initiatives can be found at www.wita.org. If you've watched any of our nearly 165 webinar panels since 2020, you know we like to call out the names of some of those you were in community with today, even if you can't see them on Zoom. So welcome today to Caitlin Costello at the USITC, Bill Reinsch at CSIS, Peter Algier at Nauset Global, and Carolina Castellini at the Embassy of Brazil. Welcome, Caitlin, Bill, Peter, and Carolina, and welcome to all of you. If you're watching this on Zoom, you can ask questions of our panel using the Q&A tab on Zoom. You should have received a copy of today's program and biographies of our speakers by email, so we can dispense with lengthy introductions. Today's event grew out of an article our speaker Bruce Hirsh wrote in January, questioning the wisdom of filing a case at the WTO that questions the judgment of a country as to when its national security interests justify raising tariffs or otherwise disregarding multilateral trade rules. I thought, why don't we just get Bruce on a Zoom webinar to discuss his thinking and talk about it with some of Washington's leading trade lawyers and commentators on WTO jurisprudence. So welcome today to Tim Keeler, a partner at Mayer Brownton, a member of WITA's board of directors, Simon Lester, the president of worldtradelawnet, of course, the author I mentioned, Bruce Hirsh, principal at Tailwind Global Strategies, and our moderator, my good friend, Stacy Ettinger, a partner at K&L Gates. Stacy?
Thanks, Ken. Good morning, everybody, or good afternoon, wherever you're located. Let me just set the stage, and then I will turn it over to our esteemed panelists. So as Ken mentioned, today we're discussing, the discussion involves the security exceptions set forth in GATT Article 21. As a general proposition, the security exceptions offer affirmative defenses in WTO dispute settlement. As the panelists are going to talk about, the U.S. has long maintained that the GATT security exceptions are self-judging, and the security decisions are non-justiciable in WTO dispute settlement proceedings. So in other words, at least from the US perspective, issues of national security cannot be reviewed in WTO dispute settlement, and the WTO has no authority to second guess the ability of a WTO member to respond to a wide range of threats to its security. So our panelists today are going to talk about various sort of issues related to the national security exceptions or the security exceptions, and also talk amongst themselves and hopefully argue a little bit over these issues. So Bruce is going to go first and is going to tee up the article that Ken mentioned, and looking forward to hearing the sort of summary of your thesis and why you wrote the piece. And then Tim will chime in after that, and Simon after that. And we will, again, as Ken mentioned, put questions in the chat. I may hold them to the end. I may tee them up if they're in the moment. And Anyway, looking forward to hearing what our panelists have to say. So Bruce, turning it over to you. Thanks.
Thanks very much, Stacy, and thanks, Ken, for inviting me. So first, just starting off with why I wrote the article. After the WTO panels came out in December, finding against the United States, a lot of the commentary in the press and elsewhere was focused on the U.S. reaction and the U.S. rejection of the panel outcome. And there was a lot of commentary drawing conclusions about what this meant for the U.S. participation in the WTO, whether this was U.S. rejecting multilateralism. And I found myself having a bit of a Princess Bride moment when I was reading all these articles. And I found myself thinking, I don't think that means what you think it means. And specifically, given the fact that the United States had been, very, very clear for 70 years that this was self-judging, that it couldn't be litigated. It should not have been in any way, shape, or form a surprise that this was the outcome, since it would have been the outcome at any point in the last 70 years under presidents and administrations that were unquestionably multilateralists and promoting the WTO. The fact is that this would have happened anytime, but it didn't for the most part over the last 70 years because there were strong norms against actually invoking the exception, but also because when it was invoked, there were efforts diplomatically to manage the situation and to avoid a situation in which you would have a panel that was going to be judging a member's decision to invoke security. That didn't mean that they were immune from processes and procedures to rebalance as a result of the measures taken. The US had acknowledged that you could still litigate the issue of what the trade effects were and thereby rebalance without a judgment on the actual issue. So, the question was, what did this accomplish? And really the answer was very, very destructive, because no matter how the panel was going to come out, you were in a lose-lose situation. Either they were going to say it's totally self-judging and reinforce that this is potentially a loophole, or they were going to come to the result which they did, which was going to be rejected and which was going to undermine the dispute settlement system, which doesn't need that right now, given its current status as broken. Beyond that, it was really a question as to why you'd bring a case when the outcome of the case was going to be the same, whether you brought it or not. That is to say, U.S. rejects the findings, the complaining party is entitled to retaliate. But again, the U.S. has always in the past been willing to litigate the amount and acknowledge that retaliation was available. So why bother bringing the case? At the same time, I'm making the point in the article that this does complicate the discussions which are underway to revive the dispute settlement system. The U.S. has indicated already that this is going to have to be a topic. It also complicates the politics here, because there are some, maybe even on the panel, who think that we shouldn't be reviving the dispute settlement system. And this is going to reinforce their views. My take is that the U.S. reaction, which is simply rejecting it, makes very clear that there isn't a risk from that kind of risk from reviving the dispute settlement system. We can always just say no. It's always been an option. It remains an option. So, to the extent that there are those who believe that reviving the system is problematic because it will stop us from acting against China or stop us from being creative with our industrial policy, it wouldn't. It wouldn't, because we can take the decision to do what we need to do. And in fact, to the extent that the dispute settlement system is operating and functional, we can at least contain the fallout from those kinds of decisions, because dispute settlement limits retaliation to the effect of the original measure, as opposed to what we saw during the Trump administration, when there was no referee and both sides would just engage in tit-for-tat trade wars that spun out of control. So that's the basic premise of my article, that the cases probably should not have been brought. There should have been more care taken as to more thought given to the potential consequences of the case being brought, but that we still need to forge through this and revive the system with the necessary reforms, which is another topic. Thanks.
Tim, go ahead and I'll let you jump in on there on what Bruce said and take the conversation where you want to go. Tim, I think you're on mute. Sorry.
Okay, how's that? Okay, thank you. So I'm going to talk about Bruce's thoughtful piece, but also give some thoughts about the panel decision and also where I think the United States will be going forward. And to be clear, these are all my personal views, none of my clients or my law firm. So just to sort of be very clear. So for Bruce's piece, I agree with the history he lays out, the facts, but not necessarily his conclusion. I think these decisions by the panels, in my view, are actually arguments against restoring the dispute settlement system, at least how it was previously constructed. I think the U.S. should not and will not accept the premise that we can just agree to a system knowing that we will just go outside of it or knowingly decide to explicitly violate our international obligations. I think Bruce downplays the legal and political impacts of losing decisions that are adopted by the dispute settlement body. I don't think he's persuasive on that front. The winner of an adopted report gets an enormous chip in a sort of larger negotiation set. The U.S. system tends to almost when the WTO system, dispute settlement system, is actually functioning, and people actually, in DC, care about it. I don't think that's the place we're in right now, but in the past, there was almost a pre-implementation of either decisions or what people thought the WTO rules required, because at every step of the legislative and regulatory process, there was typically debating a WTO consistency, and this still actually happens now, even with a non-functioning dispute settlement system. So. No, that Bruce in his piece said the WTO doesn't have black helicopters. I think that's a bit of a straw man argument. They don't need them or an army, but it's a straw man because I think it is being on the losing side of an adopted a panel report or appellate body report is enormously impactful. It is both. A binding decision under international law, but it has enormous persuasive effects. As for the panel decision, I think these decisions are deeply irresponsible. I don't think, in fact, I don't necessarily blame the other parties for bringing the cases as much. I think the decisions themselves are deeply irresponsible. If your goal is to have a return to the status quo ante of a binding dispute settlement system with an appellate level review, I think these decisions are potentially catastrophic, or on it really puts it on thin ice, to use a term of phrase used recently. Not to mention being legally wrong. Fundamentally, to me, it feels like the panelists, like the appellate body before them, just did not have the humility to say something is not legally justiciable. That it was driven by an assumption that every action must be judicially reviewable by the WTO system, and it felt like it was they sort of they couldn't help but grab the ring And I think from the US perspective, there's a real fear that over time, that dynamic would develop into a situation where a national security review becomes essentially a proxy for a policy preference for whoever is sitting in judgment in an international tribunal. I think Bruce is correct that no previous U.S. administration nor any future U.S. government will agree or even accept any foreign tribunal passing judgment on a national security-based action. That's true both if it was to determine if there were sufficient grounds to do so, whether it was truly an international emergency, or even the question of whether a decision was taken, a national security decision was taken in good faith. I think this result puts, to my mind, you can see some absurd results in some of these decisions where panelists are looking at a state of relations between two countries and trying to decide if it has reached a point of being sufficiently an emergency. To my mind, this is just a completely absurd result. It's utterly preposterous that you could have essentially law professors sitting in judgment deciding whether a country can take deterrent actions to head off a national security crisis, that the incentive structure would be that bombs need to start dropping or actual invasions or something before you can legally invoke it. It's just almost childlike reasoning in my mind. If they put themselves in this box canyon that just leads to completely absurd results. And I think the points of the U.S. ambassador to the WTO is well taken. U.S. will not cede decision-making over its essential security to WTO panels. The Biden administration remains committed to preserving U.S. national security, including by protecting human rights and democracy across the globe. For over 70 years, the U.S. has held a clear and unequivocal position that issues of national security cannot be reviewed in WTO dispute settlement. The reports disregard the reality of sovereign nations who must anticipate, not react to, issues of national security. The WTO as an institution has no business asserting its own standard that action may only be taken when it's too late. And they call for essentially an authoritative interpretation by members to address this. I think it's notable, as Bruce mentioned, that the U.S. was very clearly open to a non-violation nullification and impairment claim, which strikes me as a very appropriate off-ramp. And I think notable that even in the Trump administration, they essentially continued what appeared to be the U.S. position from 30 years ago. But the biggest reason I think these decisions are deeply irresponsible, it really, to my mind, calls into question whether panels or a reconstituted appellate body can neutrally interpret any words. This was obviously a huge issue for the United States. There's no way the U.S. would have voted overwhelmingly for the Uruguay Round Agreements Act if this hadn't been, if there's any view that this kind of outcome could happen. Ken can probably attest that this very issue was debated extensively, and the Clinton administration gave tons of assurances about this question and how the words it would be considered. So I'm sorry I've gone on probably too long already, but I'll wrap it up there. Thanks.
Thanks, Tim. And folks, Stacy is fine, but she had a fire alarm go off in the building she's in and had to move her location. Hopefully she'll be able to jump back on from wherever, either the alarm's not going off or a safe place, but just jumping in on her place. And Tim, yes, you are correct. And we're going to turn to, I was there in the beginning. But when I was working on the Senate Finance Committee in 1994 with the committee, this issue came up directly. One of the people who was raising it, interestingly, was Bob Lighthizer, who was then a lawyer in private practice. Members were raising it on the committee in private meetings, in public session. There were letters that were written assuring the U.S. of its ability to continue to use these exceptions in the national security and relation to sovereignty and other issues. So definitely have been issues that have been there from the beginning. Simon, welcome to hear, looking forward to hearing what you have to say.
Well, thanks, Ken. So I think I'm mostly going to respond to Bruce, but I do have something for Tim as well that we might be able to argue a bit about. I know everyone likes to see the back and forth and arguing. So my general take here is that when a government invokes national security, it's basically a statement that it's not going to change or modify the measure at issue, even in response to a finding of violation. Maybe that's not always the case. Maybe you could say this government or that government is willing to litigate it, make adjustments. But I think most of the time it's true. And I think in the case of the US, it's true. So as a result, I don't think that litigation is very productive here. And I mean, here, I think I'm just agreeing with everybody else. You know, does this measure violate? Is it justified under a national security exception? I mean, those are fun issues to write op-eds and law review articles about it, but there's just not much practical impact because the government's not going to change. And in terms of the broader impact on the system, well, it just calls negative attention to the system as governments refuse to comply. So what could we do instead of this litigation? Well, litigation about whether the measure is consistent or justified with the exception. Well, the U.S. says, you know, this is what Bruce and Tim have talked about. The U.S. says bring a non-violation nullification or impairment claim in order to get a rebalancing of concessions. The problem is, and this is one where I think, you know, maybe we want to dig down a little deeper. I want to hear what the others have to say. It's hard to win a non-violation complaint as it's traditionally thought of. There's a higher burden of proof. There's a requirement that the measure can't have been reasonably anticipated. There's also this question, and I know I've been in a debate with some others about this, curious, maybe too much in the weeds even for this panel. You know, does the normal retaliation mechanism even actually apply, or are parties just supposed to settle the case? So I'm just not really sure that non-violation claims can be effective. And if this is what the U.S. has in mind, just bring a non-violation complaint, I don't know that gets us to rebalancing. But I want to, you know, if others have thoughts on that, we can, you know, dig down a little deeper in it. So what I've suggested instead is some form of automatic rebalancing, and the safeguards rebalancing process could be a model for this, although people tell me that hasn't worked that well, so we probably have to refine it a bit. So basically, under this approach, it would be fine for any government to invoke national security and impose trade restrictions. But once they do, they have to accept trade restrictions imposed by the affected members or offer compensation. That would actually be ideal. So we're going to impose tariffs on steel and aluminum. Well, we're going to lower tariffs on some other product as compensation. This wouldn't be a totally unsupervised process. If parties can't agree on the amount of trade affected, which is likely that they won't be able to agree, we can have a kind of a quick arbitration process to decide on it. So this is all pretty simple and straightforward. I think the question just is, well, you know, what do governments think of this? And when I say governments, you know, what does the U.S. think of this? I'd be curious. I think this could work. I think it's the best approach. I don't know what the U.S. thinks of it. One last point I want to make, well, I'll mention Tim's as well. One last point I want to make. So there's this question of, you know, was it, I mean, our panel, the title is, was it prudent to bring these cases? So what should these governments have done instead of bringing WTO complaints? And so I think it's important to keep in mind they were in a difficult position under their domestic law, I think, at least in some cases. They didn't want to do something that could be challenged in domestic court. So they latch on to this safeguards rebalancing theory, arguing that, well, the Section 232 tariffs are really just safeguards. And so therefore we can rebalance as if they were safeguards. What I'm curious about, I'm happy to, you know, hear what others on the panel have to say, is what if they had just done the rebalancing and not filed the WTO complaints against the Section 232 measures, just declare that, well, look, we know the U.S. isn't going to comply, so we're not going to bother going through the complaint. We're just going to go straight to the rebalancing. Would the U.S. have accepted that and said, yeah, that's a good solution here? We've basically got rebalancing. So that gets you basically to where I want to go. I'm curious to get others' take on that. How would the Trump administration have reacted if everyone just said, yeah, you know, it's fine, you can do that, we're just going to rebalance? Just a quick response, Tim. I don't think he's going to like this, but so he's very critical of what the panels said about national security. I do want to point out here that there are some early cases in the 1990s, back when the U.S. liked the appellate body. So we have the panel report in the shrimp turtle case, for example, where we have a panel that many people thought made a finding that was a little too intrusive into regulatory autonomy, into national sovereignty, and then you had the appellate body step in and correct it a bit, and give a little more deference to governments to regulate. And the appellate body has changed over the years. I'm not going to sort of predict what the appellate body, as it would have existed at the time, would have said about these. It would say about these national security reports. But there is a possibility that a politically astute appellate body would say, "Yeah, we're a little skeptical. We think these panels went off the rails here. We'd like to rein them in a bit. Maybe we do need to make sure that governments have the ability to regulate when they claim national security." The appellate body could have been the fix here, is what I'm saying. I'm sure Tim will disagree with me on this, but I'd like to hear his response. So I'll wrap it up there.
I don't know, Tim, if you want to jump in here, or should we go back? We can go back to Bruce, and then we can.
Sure, happy to. I'll start in reverse order. I suppose it's possible the appellate body could have reversed the panels on these questions. I'm very skeptical. I mean, that was kind of, the shrimp turtle slight pullback, but still fairly rigorous final outcome test and hoops to jump through. I don't think would be necessarily a predictor of how the appellate body would have come out here. I think it's much more likely, or at least based on the body of the appellate body of work, that I just think it's very, very unlikely that they would have come out a different way. I can't rule it out. I mean, we'll never know. I think the U.S. is probably much happier to appeal into the void and make sure that the panel reports never actually get adopted by the dispute settlement body, as opposed to actually having to test the question before the appellate body. But I suppose it's possible. We can't rule it. We just don't know. I think the question of what would the Trump administration have done if the cases were not filed, and rather that people just took the position that it was in the 232 steel and aluminum tariffs were illegal safeguards, which they did take that position. They did retaliate. That's a great question. I really don't know the answer to that question. I think it's certainly possible that the Trump administration would have done, Simon, what you lay out. That it's possible they may have said, they're retaliating. We think what they're doing is transparently, knowing, we have an actual text-based argument on the national security. This is not a safeguard. They are claiming it's a safeguard, and that we're not implementing it properly. That's ridiculous. They just found a provision that would allow them to retaliate without having to get an adopted report to and arbitrate the number. I think there's a good argument that they might not have wanted to put the question before the WTO, and that they would have just done what they ended up doing anyway, which is with some countries negotiate different outcomes, and with other countries just take the retaliation and leave it be. I think, but as I'm saying it, I think that's probably the more likely outcome that's probably how it would have played out. But again, it's counterfactual, so anything's possible.
We love counterfactuals here. Bruce, quite a few things have come up in the last few minutes. What are some of your thoughts on some of the things that have been said, and where would you like to steer this a little bit?
Sure. Just starting with where we just left off, it's worth recalling, and correct me if I'm wrong, but the U.S. did challenge those safeguard measures, so-called safeguard measures, as an inappropriate use of that counter, that those were in fact WTO inconsistent in themselves. So at least in the context of what was actually done, we know that the US reaction was, well, that's hypocritical and WTO inconsistent. But the better question is, what would they have done if there had been a suggestion made or a receptivity if the US actually did offer, the kind of litigation over the amount of rebalancing which had taken place in the context of Nicaragua, the Nicaragua case back in the 80s, and which Simon has now proposed as a methodology going forward. And there I do suspect that they would have been receptive to it, because that has traditionally been the US position. So there was an option here. There was an option short of just pretending it was a safeguard so you could immediately retaliate, which is what they wanted to do, or litigate, which is where they went in the end. They could have offered this kind of process. Now, Simon makes the point, about whether you can actually litigate on a non-violation claim successfully, and that's a good point. And it just raises the question as whether the U.S. would have insisted on that. Again, they came up with special terms of reference in the 80s when the U.S. Put an embargo on Nicaragua, and it was subject to potential litigation. And the special terms of reference basically specifically referenced trade effects. So, that option could very well have been available now had the parties agreed, had they been willing to work on through a diplomatic channel to come up with a resolution that wasn't going to stress the system in the way that these did. Returning back to some of Tim's points, I'm glad he agrees with me where he agrees. But first of all, I just want to make very clear that as can be seen from a lot of the writing that I've done and the work that I've done over the years, I most definitely do not believe that we should be reconstituting the system as it was before. I have a number of papers which are readily available that I did even a couple of years ago on reforms that I think would be necessary. And now we are waiting for the U.S. to put forward some of its proposals and for others to be putting forward proposals, which I suspect will dramatically change the way second-tier review works, if there is second-tier review at all. And I totally understand and appreciate the importance of that. So I think simply reconstituting the system is not something which is I think a good idea. My point is that there are discussions to get the system working again with the necessary reforms, and that those discussions have really been set back by this decision. On the point of whether this notion that you can disregard, well, let's back up. The notion that there is a lot of force and effect to a decision against a party, that means that it's not so simple to simply disregard it. 2 points there. First of all, there have been many instances which of noncompliance that have gone on for decades. Many parties, including the United States, including the EU, including others, have to, on a relatively regular basis at the DSB, explain that why they have not yet implemented decisions from a few decades ago. And the answer typically is it's really hard. So it does happen. And it's also, while it is absolutely correct that these decisions are do have a tremendous amount of value in persuading parties to comply, that value is largely relating to the fact that the members themselves have an interest in complying so that others do. It's very much a dynamic which was already at play in the GATT before there was automaticity in dispute settlement. It was still true under the WTO. But we also have to remember that even in the DSU itself, in the dispute settlement understanding that governs WTO disputes, there are options for non-compliance. So while it is absolutely true that these are, quote, binding under international law, we also have rules in the WTO for choosing not to. There are rules that permit compliance, or rather compensation. There is a provision for retaliating. So, I mean, in a certain sense, the dispute settlement understanding can be seen as really a rebalancing mechanism as much as anything else. And in the current environment, it maybe is better to start thinking about it that way, because there are issues that are arising, involving one particular member that may require action outside the system. So if the conclusion is that we cannot restore the system until we are in a position to deal with that one member in a way that we can win cases or that we won't lose cases, then that's a recipe for not restoring the system. I rather think that we have to acknowledge that when it comes to China, that we're dealing with an outlier in many ways, that we may not be able to respond to them using traditional WTO dispute settlement techniques, and we have to be clear and open about that fact. But we also have to be open about, clear that simply because we are applying that standard to China, that is to say, accept that we're going to be going outside, that we not apply that standard to the rest of the membership. If for no other reason than we need allies with respect to our dealings with China, and those allies expect us to be, treating anything we do with China as the exception and not the rule. So for any number of reasons, I think that, we do need to restore the system. We need to do so with open eyes as to what we can do until, if ever, there are adequate rules with dealing with China that we are willing to go outside. So in that sense, I think that we do want to restore the system. We have to acknowledge that, of course, compliance is to be preferred, as the DSU says, but we have to be open that, at least with regard to the challenges which face us with regard to China, we're going to have to go outside.
Tim, I wasn't sure if you wanted to jump back in, because I want to bring in some audience questions in a moment.
Just one, actually, I have a question for Bruce.
Please.
Because yes, his of course, as always, his recitation of facts and the facts of the non-compliance are correct. What in thinking about his article and thinking about his comments right now, what I can't tell is, Bruce, do you think the U.S. should, as a precursor to should any final outcome include an exception for national security that is clearly unequivocally self-judging? A member raises it, panelists help people go pencils down immediately. I actually realized, I thought that's what your view was, but then your recent comments, now I can't tell if you're arguing no national security exception, self-judging exception, but let's just live with non-compliance.
No, I was speaking more generally about the restoring the dispute settlement system and the point you were making about whether you can disregard it. And certainly in the cases of national security, it's going to happen, as you mentioned. I mean, any future administration is going to do exactly what this administration did or what any past administration would do. But more generally, I think that there really is a debate taking place, in the United States right now, where WTO dispute settlement is being equated with a domestic court in terms of its impact here. And I was trying to respond to that point in saying that there are no black helicopters, because there are those who believe, or again, this is wonky. This is Geneva. This is far away. That believe that if a WTO panel or appellate body rule against the United States, that the National Guard can enforce it. And that was the point I was trying to make there about the black helicopters, is that those who are saying we shouldn't restore the system because these findings will be coming out against us, and we can't afford that, don't understand that there's a more subtle point at the WTO where there is at least an option of not complying, even if that's the strong preference. In terms of what we should be doing with the national security exception, I think that, we already know that the United States is going to be trying to engage on this issue as part of the dispute settlement discussions. They've indicated that they would, and we know they will. Ideally, yes, there would be some sort of agreement on a mechanism like as Simon proposes, in which we can figure out a way forward when these cases arise in the future. I would note that Simon's proposal really doesn't force one to answer the question of whether it's self-judging. If, in fact, a national security process or procedure will automatically be directed to this issue of rebalancing, then those members who are not comfortable saying that it's totally self-judging can, are not going to be compromised, but neither would we. And, at the end of the day, let's recall, some of the language which was used at the very outset of the negotiation of this GATT language, where it really was going to be the atmosphere among the membership that was going to constrain the use. That is to say, it was the norm that was going to constrain the use. So there will still be room in the future for members to argue this is an inappropriate use of it, which is what happened for 70 years. And for others to say that this is totally self-judging, which, again, I would point out, is a position that virtually every one of the complaining parties in the recent litigation has taken over the last 30, 40 years. All of them have said this shouldn't be resolved at the WTO at the very least, and some have even agreed that it's self-judging. But it is a way of avoiding this question. Now, ideally, sure, it'd be great if we could get agreement among the membership that it is self-judging, but that this other mechanism is in place. But even failing that, avoiding litigation, somehow, having debates over the appropriateness of when to invoke it, to reestablish some sort of boundaries for the norm, all of that would be fine. But obviously it's going to be difficult.
So I'm going to jump in, and Simon indicated an interest in answering this first question that came in, but I'm going to read it, Simon, and add a little to it. So Lou Leibowitz, who many of you know, sent in a great question. Does the WTO's decision undercut the ability of a member state to act in its national security interest when the consequence is at worst retaliation after due deliberation? Clearly, the specific actions taken to address national security interests could violate trade agreements. Why is it not legitimate to address these issues through negotiation, compromise, and when necessary, dispute settlement? I'm going to add, Catherine Tai at the Munich Security Conference last month thought that the DSU Act, and in relation to this case, I think in much cases, DSU activism hampers the negotiating function, and litigation shouldn't create the rules that negotiations should achieve. Simon, thoughts?
Yeah, so I think this is a great question. And I think it undermines perhaps something I've been saying, we've all been saying, and I just kind of, want to see what everybody has to say about all this. So, what I've been assuming is that the panel findings of violation are bad for the system because, let's say the US or other governments won't comply. But if a violation leads only to rebalancing, is it really is a litigation of that sort really any different than just a non-violation complaint where you just look at nullification or impairment? Why does it matter that the panel has said the U.S. is in violation when we all know the U.S. doesn't have to comply and can accept rebalancing? What is it about the panel saying the U.S. is in violation that is such a problem when, I understand there's a misunderstanding maybe out there in the general public, but we all know the limits of the WTO system. As Bruce said, there are no black helicopters. All a violation does is set the stage for rebalancing, which it seems like we all agree that's where we should go. So why does it matter? So maybe I'm wrong. Maybe this isn't bad for the system. I guess I'm particularly curious what Tim has to say here, but also Bruce, why does it matter so much that the WTO panel said there's a violation? That just gets us to the rebalancing, and that's where we all want to go.
Well, a couple thoughts. I think it does matter quite a bit. I mean, I think as a general matter in trade debates, typically when these kind of questions are, should we take on this obligation? Folks will make the argument, well, look, at the end of the day, if we're found in violation, it's not a big deal. But then when you actually have a violation and people, the same folks will turn around, not saying these folks will call, but the same cohort of groups will say, the U.S. is a scofflaw. The U.S. is an absolute outlaw. This is against our international obligations. We are breaking the law, and you need to make a change. Now, yes, this is not things that are enforceable in domestic U.S. courts, but it is as a matter of law, international law, and the U.S. cares about that, should care about that. It is meaningful. So if you're going to have, I think it does matter on that basis alone. If you're going to have a national security exception, I mean, Lou's question I took to mean, what's the big deal with international tribunals deciding whether the exception is met on the merits or whether it was done in good faith? I think it just gets back to my earlier points of these are absurd propositions. It's absurd that a foreign tribunal could peer into the minds of the Secretary of State or any foreign minister or a leader and decide whether it was really enough of an international emergency or whether it was really done in sufficient amount of good faith. So I think if you're going to have a national security exception, it is not really a question that is legally answerable, and therefore the idea that it's self-judging. But then you get to the rebalancing. I mean, to my mind, the rebalancing question is the cost to be paid, which would happen whether there was a formal process, as we've seen, whether it's a formal process or not. The rebalancing will there'll be a reaction and people have to take it. So it feels odd that I feel like I'm the one who's pushing these decisions by these tribunals matter. And that's why we need to take them seriously and not pretend that they don't matter. They're very serious, and I think the impacts are large. I will say, when I was chief of staff, there was a proposed line item for USTR for black helicopters. I did zero that out, and that's why we don't have them. So you're welcome. But anyway, those are my thoughts.
Thanks for clarifying that last bit. And I will say, believe it or not, the black helicopters thing actually did come up when we were talking about it. That was one of the things that we talked about in the finance committee. Was right. It was about a year after Waco, and people were saying, is this global trade organization going to come in and change U.S. law?
Actually, let me make one more serious point, which is I'd turn the question around to Lou and Simon, which is, if you can get to rebalancing outcome anyway, what is so important about having a legal finding of whether the national security exception was properly or legally invoked? Because that dynamic you're talking about would be, let's say a panel or appellate body found that it was a sufficient international emergency such that you could get the exception. Well, at that point, you have no rebalancing. So these decisions would be highly, highly fraught with and highly charged, and really, really detrimental to, I think, having any system at all. I don't think you can have a binding or automatic adoption process without having a non-justiciable national security exception. I think if you don't, I think it will absolutely destroy any system.
I think that's a good point. You've convinced me of my original view, so thank you.
And the one thing I would add to that is, just remembering when these provisions were all put together. This was being put together in parallel with the construction of a United Nations system that was dealing with political matters and dealing with these kinds of matters. And in the context of putting together that system, we agreed to the review of U.S. national security decisions. In the Security Council, it was subject to our veto, for example. So the notion, and this was the argument at the time, that you would have trade experts or the people who were focused on economics and trade, sort of bypassing the the procedures that had been agreed for dealing with security issues was not something that made sense to the United States, at least, and to others as well. And again, this was the argument at the time. This was the argument since. And again, many of the complainants, among the arguments that they would make, even if they weren't arguing over the last several decades that it was completely non-justiciable, they would come in when these issues arose and say, this is not the right forum for determining this kind of issue, which essentially came to the same thing and comes to the same thing. So, again, from the perspective of if concern for not breaking the system, then the rebalancing is the right way to go, because that is the limit perhaps of what you can accomplish in a trade organization in dealing with this kind of issue.
So I want to just bring in a question. Chris Turnbull asks, if we were to move to an approach of increasingly seeking to resolve these types of disputes through these types of matters through non-violation complaints, compensation, rebalancing, how would you suggest accounting for power imbalances among members?
Well, look, I mean, the same way that they were dealt with for 70 years, you work diplomatically to try to recreate or create norms that are going to prevent this from being overly used. Again, I'm sure that as part of the debate, if that is going to take place, that's likely to take place as part of the dispute settlement negotiations on the appropriate use of national security exception, there will be plenty of opportunity to elaborate on what members feel are the appropriate times. And, for better or worse, this may well be the only effective way, to really rein this in. The power imbalance that, is referred to in the question existed for the last 70 years. However, the interests of the United States and others in ensuring that the system was going to work meant that there was a restraint in exercising the exception and actually invoking it, and that ultimately is I think going to need to be the dynamic which is reinstated.
So I want to bring in two questions from folks, a couple more folks that people know out there. Eric O'Toole writes, arguably, the national security exception under the international trade rules has worked and generally been non-controversial because countries exercised restraint in invoking it. To what extent do you think the results of this panel reflect concern that the way the U.S. is now viewing this exception as could potentially blow a hole in international trade rules by allowing any trade restrictive action to be justified on the grounds of national security? Segue from that question to one from Uri Dadouche, which is similar. Most observers consider the invocation of national security imposed on steel and aluminum from allies to be absurd. What are the implications of not litigating in the WTO for the trading system's ability to enforce rules and for the behavior of other members inclined to protectionism? Simon? Simon, I think jump in first and then.
Let me jump in on Uri's. So I think that, my answer here is that there's a political reality that we all have to take into account when constructing this trading system. And we all have our ideals. I probably, I'm more on the free trade side than, well, I don't know who else is on the call, but I'm very much on the free trade side of things. And so, in my ideal world, there would just be everybody agreeing not to have protectionist trade barriers. But I also recognize the political reality, and you have to make exceptions. And there are tariffs that are in the schedules that you can use, and you can pose safeguards, all these various things. So there's a political reality of what can be covered, what the system can handle. So do we have rules covering intellectual property? Do we have rules constraining anti-dumping countervailing duties? And similarly, do we have international constraints on the use of measures for national security or not? So, the question is, what are the implications of not litigating about it? The implications are we've limited the scope of the system to account for the political reality that, some important members, one in particular, don't want this covered. I think we can all agree we ideally the trading system would include the United States. We want the United States in the system. So what are all the things the United States wants? What compromise can we come to? And similarly, I mean, every government out there has certain things it wants and doesn't want in there, and we all get together and we come to a compromise. If the compromise is national security can't be litigated, yeah, I mean, maybe that strays from the free trade ideal that I'm pushing for, but I mean, I'm also a realist, and we can only achieve so much, and if that's what we can achieve, I can live with it. I can still make the arguments and try to convince the U.S. to think a different way, but I'm open to compromise here. If that's the compromise, I can live with it.
Tim, did you want to? I couldn't tell if you want to jump back in.
Well, yeah, no, I think I largely agree with Simon's assessment that it's not really, it's a bit of a false choice to say, well, what if, this sort of use of national security exception undermines the system. There is no system without a national security exception. It's very, very pie in the sky. It is very unrealistic. There is no system. You have the status quo right now where I guess that's unfair. There is a system. There's a system where, panels can be formed, reports can be issued, unlike the GATT, but then they can get appealed into the void and not adopted. So, like the GATT, that is the status quo. There is zero possibility of any system of automatic adoption of reports, which, to be clear, I'm not sure if that's even possible to get back to, but I'm certain it's not happening without a self-judging national security exception. So I think also, as a practical matter, it seems like every government, every country, and everybody on the panel agrees, even if national security exception use of invocation is non-justiciable, you would still have a rebalancing, and whether it's a self-help rebalancing or a rebalancing that is blessed through a non-violation claim. That's the check, and that is actually a pretty meaningful check. As we're talking about it, in some ways that might be a more meaningful check than if you did have actually, if it were justiciable and you had panels or appellate body agreeing that it was properly invoked, which would at that point afford no rebalancing. So anyway,
just a big Lou Leibowitz just piped back in and reminded, and just curious about this. And before we wrap up, it says Article 21 says war or other emergency in international relations. Does the language need to change, and if so, how?
I mean, to my own mind, the more relevant language, well, first of all, I think just as a reading it, it's pretty, the panel said, well, there's war and there's emergency international relations, and they must be alike each other. I read that and say they didn't limit it to just war. There were other situations, and once you get into that question, it becomes obviously a much more difficult factual situation. But the most important language was to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests, and then it lists the types of things. So, to my mind, the most relevant language, as you might imagine, is any action which the member considers necessary. That's the key language. So if they renegotiate it and do an authoritative interpretation, I suspect you won't have this type of language. You'll just have something that says if it gets invoked, everybody goes pencils down, and you don't even have the sort of guidance as to what members should invoke it for.
So let me just ask, and Simon, I know you want to jump in. Could a country, for example, say that climate change is an existential national security crisis and use that as an excuse?
I wasn't sure. Yes, they could. If that's the question, I mean, they could say that, and then we'd all have to deal with that. If that's a
Pencils
position.
down.
What's that?
Pencils down then. Like it's national security.
I think that these are types of questions that we can fully expect to arise, in the context of the conversations that are going to be taking place. And again, it is those conversations rather than a panel that are going to establish the bounds of what should and shouldn't be invoked, recognizing that, those bounds are establishing a norm and not a rule. And again, I suspect that this will be a topic of conversation, and it already probably is in the context of, some of the debates that which the EU has now proposed discussions on trade and environment, and these issues are going to be coming up.
I think these are good discussions to have, because keep in mind, when they negotiated the GATT, there were no panels. There was no sense of what adjudication was going to be like. That all developed over time. So now, having had decades of understanding what jurisprudence or what litigation has been like, what it could be like, now let's think carefully about what these words mean. Let's get government's views on what they all mean. And I'm happy to have that debate. It's going to be messy. I don't know how long it'll take. We might never get a conclusion, but I think it's worth talking about all of these sort of core terms and principles that we've all, assumed meant a certain thing over the years. Let's talk. My big criticism of the U.S. has been, you're just not telling us exactly what you want. So if the U.S. is going to put forward a proposal here on what they think GATT Article 21 should mean, have some sort of authoritative interpretation, I'm happy to hear it, and I want to hear what all the other governments think of it. I think that could get us to a better place, but it could be messy and it could take a while.
Well, and we are coming up on the 30th anniversary of the WTO going into effect on January 1, 2025. So having a look at some of that language 30 years later is not really inappropriate in any way. Thank you all very much. I've been texting with Stacy. I guess she's been allowed back in the building. Oh, there she is. She's allowed back in the building. Everything okay, Stacy?
Everything's good. I got my cardio in, running down 10 flights and back up another 10 flights. So all good.
Well, sorry that had to happen in the middle of this, but thank you very much to our discussants for a somewhat wonky but spirited debate about the DSU. Simon, did you have a final word on the topic, or did you?
No, sorry.
Okay.
Just unmute so I can say goodbye.
Thank you, Simon, very much. Thank you, Bruce, for getting this all started. Tim, thank you very much. Stacy, we'll have to be back on again, minus fire alarm. So thanks all for joining us. Really appreciate your time, and thanks all of you for sticking with us. Take care, everyone, and be well.